Hello everyone. This is a video on chapter 13 and chapter 15 of the IPC, where we will be discussing the chapters relating to offenses in relation to weights and measures, and the chapter relating to the offenses in relation to religion, right, respectively. Now, let's begin with chapter 13 first of all. Now, chapter 13 encompasses within its framework four different sections, right? Now, the sections that are incorporated in the chapter dealing with offenses relating to weights and measures are sections 264 to 267. So it's a shorter chapter as compared to the other chapters in the IPC. Now let's see how the provisions pertaining to offenses relating weights and measures unfold under this chapter. Now, I'm sure that you've heard of the concept of weights and measures and the fact that there are special legislations in place, right? So the earlier legislation with respect to weights and measures was the Weights and Measures Act 1956, which was later, of course, substituted by the Standards of Weights and Measures Act 1976, right? Now, uh, the the metric system has been adopted uniformly in this specific act. The metric system, which has been uniformly adopted for India, under which kilogram is the weight, is the primary unit for weight, meter is the primary unit for length, and liter is the primary unit for capacity, right? So liter is used as a standard unit to measure the capacity, meter being a unit which is used to measure length, and kilogram being a unit which is used to measure weight, right? Now, a reference needs to be made to section 153 CRPC here. Now, what does this section mean, and how does this find a place in this chapter, and or maybe a reference in this chapter? So, section 153 of CRPC provides that the SHO of a police station, on receiving the information that false weights or measures are being used at some place, he may seize them without a warrant and inform the magistrate having jurisdiction for initiating criminal proceedings against the offenders. Right? So now we understand as to why this specific section of the Code of Criminal Procedure is being discussed here while we are discussing a chapter on the IPC, because both the enactments go hand in hand. IPC specifying the substantive law on the subject, and of course the CRPC providing for the procedure to be followed, right? So 153 provides that the SHO of a police station, जब जब उसको कोई information मिलती है that false weights or measures are being used at some place, उसके पास क्या power है under 153 कि वो seize कर सकता है उन weights and measures को without a warrant, right? Without a warrant, and then thereafter inform the magistrate having jurisdiction for initiating the criminal proceedings against the offenders, right? Now, that being the case, let's start with the substantive um, law that has been provided under Chapter 13 of the IPC. Section 264 deals with the offence relating to fraudulent use of false instrument for weighing. So we understand that if a false instrument is used for weighing by someone, right? Now that is going to have an impact on the kind of weight that is eventually determined, right? So in case anyone's fraudulently using a false instrument, right, then the person will be liable under 264, and 264 reads as, whoever fraudulently uses any instrument for weighing which he knows to be false shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine, or with both. Right? So, what transpires through the reading of 264 is that there's certain ingredients that need to be fulfilled. Number one, the ingredients for 264 would be one, that there should be a fraudulent use of any false instrument of weighing. Number one, fraudulent use, right? And the second requirement is, of course, of the knowledge that it is a false instrument. So the fact that a fraudulent use of a false instrument has been made, right, for the purposes of weighing. That's the first requirement. And second is the knowledge that it was false, right? So these are the two ingredients for the offense under 264. 265 talks about fraudulent use of false weight or measure. Now, fraudulent use of false weight or measure, यहाँ पे था instrument for weighing बेटा. 265 में जो आ रहा है वो offense जिस चीज की बात करता है वो है fraudulent use of false weight or measure. Let's first of all read the bare provision. Whoever fraudulently uses any false weight or false measure of length or capacity, or fraudulently uses any weight or any measure of length or capacity as a different weight or measure from what it is, shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine, or with both. Right? So we understand that this specific section, which is section 265, provides the punishment, makes it an offense. What an offense? The fraudulent use of a weight or measure. Right? जैसे कि 264 में था, it punished those who use a false balance, while in under 265, the person who uses a false weight or false measure of length or capacity is punished under 265, right? So under 264, all those who used false balances, false instruments for weighing, right? Those would be covered under 264, and the persons who use a false weight or false measure of length or capacity, they would be covered under 265. Now 266 talks about being in possession of false weight or measure. So mere possession is also punishable under the chapter which provides under section 266 that whoever is in possession of any instrument for weighing, or of any weight, or of any measure of length or capacity which he knows to be false, intending that the same may be fraudulently used, shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine, or with both. So this section basically, जो 266 है बेटा, this punishes a person who is in possession of what? Of a false weight or measure, right? A person who is in possession of false weight or a false measure of capacity, right? A measure is false. Now, as far as the question of when will a measure be false, or when will a weight be false, so a measure is false if it is something other than what it purports to be, है ना? तो जो false का मतलब यहाँ पे ये है कि जो वो नहीं है, what it is purporting to be, it is not, right? So that's when a measure is deemed to be a false measure. If both the purchaser and seller are aware of the actual measure being used, there is no fraudulent intent, right? अगर जो purchaser है और जो seller है, ठीक है, जो buyer है और जो seller है, उन दोनों को पता है कि भाई जो जो weight और measure यूज किया जा रहा है वो उनकी नॉलेज में है, दे आर अवेयर ऑफ द एक्चुअल मेजर ऑफ द सेम, उनको उसके एक्चुअल मेजर का पता है. तो देन 266 would not be attracted, because there would be absence of fraudulent intent, right? Fraudulent intent needs to be there because the section itself clarifies that with the intention that the same may be fraudulently used. ये एक important ingredient है 266 का बेटा, right? Further, 267 talks about making or selling false weight or measure. So whoever makes or sells or disposes of any instrument for weighing or any weight or any measure of length or capacity which he knows to be false. So weight और measure किससे related है बेटा? Length से related measure, जो कि meter is the primary unit, right? And length and capacity. सो बेसिकली यहाँ पे किस किस चीज की बात हो रही है इस चैप्टर में? फॉल्स इंस्ट्रूमेंट की बात हो रही है, फॉल्स वेट की बात हो रही है, फॉल्स मेजर ऑफ लेंथ एंड कैपेसिटी की बात हो रही है बेटा। इनमें से कोई भी चीज अगर कवर्ड है and the other ingredients of these sections are applicable, then this chapter, the offenses under this chapter, the specific offenses under this chapter will be made out. So when we talk of 266, 267, 267 talks about making or selling of the same. तो बनाना या उसको बेचना, किस चीज को बेचना? इंस्ट्रूमेंट फॉर वेइंग को, फॉल्स इंस्ट्रूमेंट फॉर वेइंग को, ठीक है? इंस्ट्रूमेंट को ऑफ वेइंग को बेचना इज नॉट एन ऑफेंस, बट फॉल्स इंस्ट्रूमेंट फॉर वेइंग, राइट? Any instrument for weighing or any weight or any measure which he knows to be false. So false instrument for weighing, false weight, false measure, अगर कोई भी उसको बनाता है और उसको बेचता है बेटा, in order that the same may be used as true, उसको as a genuine प्रोडक्ट जो है उसको पास ऑन करना, और knowing that the same is likely to be used as true. पनिशमेंट कितनी है? Imprisonment of either description for a term which may extend to 1 year or with fine or with both. तो हम ये देख रहे हैं बेटा कि एक फिक्स्ड जो पनिशमेंट प्रिस्क्राइब्ड है अंडर दिस चैप्टर वो है पनिशमेंट एक्सटेंडिंग अप टू 1 year, राइट? 1 year और फाइन और बोथ। इन सभी सेक्शंस में ये सेम जो पनिशमेंट प्रिस्क्राइब करी गई है 1 year और फाइन और बोथ। नाउ there is an important reference that needs to be made in this regard, in regard to the provisions under this chapter. Number one, कि जो maximum punishment है that can be awarded for offences under all these 4 sections is either rigorous imprisonment or simple imprisonment, right? For 1 year, जो कि अभी हमने note किया, right? Which appears to be inadequate, in my opinion. So in view of the increase of the offences by in the increase of such offences by unscrupulous traders, तो एक बेटा लॉ कमीशन की रिपोर्ट थी 156th रिपोर्ट ऑफ 1997, 156th रिपोर्ट of 1997. Now, by that report, the Law Commission had suggested the need for enhancement of punishment for these offences, क्योंकि punishment सिर्फ up to 1 year ही है, और keeping in mind the gravity of the kinds of offences that can be, committed with respect to the fraudulent use of false instruments for weighing, false weights, false measures for length or capacity, तो उस केस में क्या है कि enhancement of punishment थोड़ी सी होनी चाहिए, but the same has yet not been accepted. अब बेटा एक बहुत ही important judgment है 2019 की latest judgment है in the case of state of UP versus Aman Mittal and others. Now, in this case, what happened was that the accused were convicted for offences under 267, 114, 120B in respect of abatement of short delivery of petrol and diesel. ठीक है? So the magistrate did not make cognizance of the offence under 471 and 120B IPC for want of evidence, but जो section 30 of the Legal Metrology Act है 2009 की, it took cognizance under section 30. Section 30 of which act? Of the Legal Metrology Act. Now, in this case, the magistrate held, after taking cognizance, the magistrate held that Section 26 of this Act overrides the provisions of IPC, as Section 51 of the Act clearly excludes the application of IPC provisions to the offences committed under this Act, Legal Metrology Act. Okay. Now, the question before the appellate court was whether the provisions of investigation, inquiry, trial, as contained in the CRPC, will apply to the offences committed under Legal Metrology Act or not. Now, allowing the appeal partly, the Supreme Court held that in case of violations under Legal Metrology Act, the provisions of this Act will apply. Right? Now, Section 51 of the Act provides that provisions of IPC and Section 153, जो कि यहाँ पे हमने बात करी बेटा, है ना, of CRPC, which relate to weights and measures under Chapter 13 of the IPC, will not apply to any offence punishable under the Legal Metrology Act 2009. Therefore, the accused were beyond the jurisdiction of the High Court, and as such, all its directions were quashed. Right? Once again, the important, relevant aspect of this judgment, let's focus on it once again. Now, the Supreme Court in this case held that Section 51 of the Legal Metrology Act, which states that the provisions of IPC and Section 153 of CRPC, which relate to weights and measures under Chapter 13 of the IPC, will not apply to any offence punishable under the Legal Metrology Act 2009. Therefore, जो accused थे, they were found to be beyond the jurisdiction of the High Court, and as such, all its directions were quashed in this specific case. Well, that's it as far as Chapter 13 of the IPC is concerned. Now, let's move our focus from Chapter 13 to Chapter 15 of the IPC, which is again a short chapter, but we will see various different provisions under this chapter and see how this chapter unfolds and provides for the offences relating to religion, right? Now, religion being a sensitive matter, and all matters relating to religion to be ensured, they are to be ensured that there are specific provisions that are made in relation to any offenses that could possibly be in relation to religion. So chapter 15 of the IPC provides for various offenses, including number 1, injuring or defiling place of worship with intent to insult the religion of any class. This is the provision under 295, which is the first section under this chapter. The second section under this chapter is 295A. Now, 295A encompasses such offense of deliberate or malicious acts intended to outrage religious feelings. Right? And thirdly, section 296, which talks about disturbing religious assembly. Fourthly, 297, which talks about trespassing on burial places. And lastly, section 298, which provides the provision for uttering words, etc., with deliberate intent to hurt religious feelings of any person. So in this discussion, we're going to be taking these up one by one and discussing certain case laws pertaining to the same. First of all, we'll be discussing the bare provision and then taking you through some judgments so that our understanding of the provisions under chapter 15 is fortified. Now, the first section under this chapter, which is section 295, which deals with the offense of injuring or defiling a place of worship with intent to insult the religion of any class. So this is the first section that we're going to be discussing. Section 295. Now, 295, the language of the section is clear enough to explain the kind of offense that is defined under this section. It says, whoever destroys, damages, or defiles any place of worship or any object held sacred by any class of persons with the intention of thereby insulting the religion of any class of persons, or with the knowledge that any class of persons is likely to consider such destruction, damage, or defilement as an insult to their religion. So we can see that this offense, the focal point of this offense is the fact that the intent is to insult the religion of any class, right? Now, in this section, a person who intentionally insults the religion of any class or defiles any place of worship is bound to be punished if the offense under 295 is made out. Now, what could be the object of this section? Object of this section is clear enough, uh, which would be the fact that the legislature intended to prevent those persons who intentionally, hurt the religious feelings of others by injuring or defiling a place of worship, right? अब बेटा अगर हम इसकी बात करें कि इंग्रेडिएंट्स ऑफ दिस सेक्शन क्या हैं, तो बड़े क्लियर इंग्रेडिएंट्स निकल के आते हैं, जो कि ऑफ कोर्स फर्स्ट ऑफ ऑल वी कैन डिवाइड इंग्रेडिएंट्स इनटू टू पार्ट्स, राइट? द फर्स्ट इंग्रेडिएंट इज दैट देयर शुड बी सम डिस्ट्रक्शन, डैमेज और डिफाइलमेंट। ठीक है, या तो कोई डिस्ट्रक्शन होनी चाहिए, या कोई डैमेज होना चाहिए, या डिफाइलमेंट होना चाहिए। डिफाइलमेंट अभी हम डिस्कस करते हैं, डिफाइल का मतलब क्या होता है। तो डिस्ट्रक्शन, डैमेज और डिफाइलमेंट किस चीज की? कोई भी प्लेस ऑफ वर्शिप की, और एनी ऑब्जेक्ट विच इज हेल्ड सेक्रेड बाय अ क्लास ऑफ पर्संस। तो कोई चीज, कोई ऑब्जेक्ट जो कि अ पर्टिकुलर क्लास ऑफ पर्संस जिनका की एक स्पेसिफिक रिलीजन है, उनके लिए वो बहुत ही सेक्रेड है, या कोई प्लेस ऑफ वर्शिप है। ठीक है, तो पहला तो ये इंग्रेडिएंट हो गया। दूसरा, such destruction or damage or defilement must have been done, number one, with the intention of insulting that religion, which we just discussed. This is the focal point of this section. The intention should be to insult the religion of a class of persons. And secondly, or with the knowledge that a class of persons is likely to consider such destruction, damage, or defilement as an insult to their religion. ठीक है, या तो इंटेंशन होनी चाहिए या नॉलेज होनी चाहिए, है ना? तो पहला तो द फैक्ट ऑफ एक्चुअली an act of destruction or damage or defilement happening in relation to what? In relation to a place of worship, or in relation to an object which a particular class of persons holds as sacred. And secondly, with the intention or the knowledge of hurting or injuring the religious feelings of any particular class of persons. So, next question that needs to be seen after discussion on the ingredients is, what do you mean by the expression defiles, right? ये एक नया expression है जो हम इस section के through पढ़ते हैं बेटा। Now, meaning of this word is not restricted to the acts that would make an object of worship unclean as a material object, right? But extends to acts done in relation to the object of worship which would render such object ritually impure, है ना? So rendering of an object of worship ritually impure is defilement, right? It does not only mean making dirty, किसी चीज को गंदा करना, but it also means means making ceremonial pollution, right? तो ये जो एक एक्सप्रेशन है जो कि मतलब डैमेज करना, डिस्ट्रक्शन करना, उससे थोड़ा आगे जो कि रिचुअली इम्प्योर कर देना किसी चीज को, है ना, कि वो रिचुअल्स के लिए अप्रोप्रिएट ना रहे, राइट? सो दैट्स कॉल्ड डिफाइलिंग. Now, the damaging or destroying of a sacred thread, which is normally by a person who is not entitled under the Hindu custom to wear it, or for whom the wearing of the sacred thread was not part of his ceremonial observance, would not fall within सेक्शन 295, राइट? जो थ्रेड्स होते हैं जो लोग पहनते हैं, अगर if it is not, if such a person is not entitled under the Hindu custom to wear it, or for whom the wearing of the sacred thread was not part of the ceremonial observance under the Hindu religion, right? So, in addition to this, there's a case law which is of DP Titus versus LM Leal. DP Titus versus LM Leal, which is a 1981 Allahabad High Court judgment. In this case, the High Court of Allahabad held that running a nursery school and a charitable dispensary, एक nursery school and a charitable dispensary by the pastor of a church, did not constitute an offence under 295, as neither there existed an intention to insult any religion, nor feelings of any class of persons, nor was there any destruction which was made by such a person, right? So, just running a nursery school and a charitable dispensary by the pastor of a church did not constitute the offense under 295. We understand, right? Clear case hai ye, wherein the ingredients of 295 are not made out in this case. Next section is 295A, which provides that whoever with deliberate and malicious intention of outraging the religious feelings of any class of citizens of India by words either spoken or written, or by signs or by visible representations or otherwise, insults or attempts to insult the religion or the religious beliefs of that class, shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both, right? So हम अगर इस specific section को जो है dissect करने की कोशिश करें, तो basically what this section deals with is deliberate and malicious acts. And the intention behind the deliberate or malicious acts would be to outrage the religious feelings of any class by insulting its religion or religious beliefs, right? So under this section, कोई भी person जो कि deliberately या maliciously outrage करता है किसी की religious feelings को, shall be punished. Now, the provocative and outrageous remarks should be such as are bound to be regarded by any reasonable man as grossly offensive. This is important to be, focused on, that a reasonable man would find it grossly offensive and deliberately intended to outrage the feeling of any class of citizens of India. So, जो provocative and outrageous remarks होते हैं, they are to be judged from the assessment of a reasonable man of that religion, professing that religion, right? इसमें एक interesting case है सुजाता भद्रा versus State of West Bengal का 2006 Calcutta High Court. The facts of the case are that जो petitioner who was a citizen of India, Sujata Bhadra, she filed a petition for setting aside the order of forfeiture of a book which was written by the author Taslima Nasreen. I'm sure that you've heard of the name of the author, Taslima Nasreen, who is from Bangladesh. उनकी एक बुक आई थी जिसका कि नाम था द्विखंडिता. द्विखंडिता. I can write them down here for you. Taslima Nasreen की ये बुक थी. Now, there was an allegation that there was certain objectionable material uh, in relation to volume 3 of this book. Okay, this was in 3 volumes, which was a trilogy, right? Trilogy thi ye, and this was basically an autobiographical trilogy, right, of the author. So she herself, being a Muslim woman who professed the Muslim religion, had written the alleged offending part in context of what? In context of status of women in the society in Bangladesh, है ना? तो उसने अपनी कंट्री में जो स्टेटस ऑफ women था in the society in Bangladesh, उसके बारे में लिखा था, emanating from the adoption of Islam as a state religion, right? So, because Islam was adopted as a state religion by Bangladesh, so as a result of that, जो स्टेटस ऑफ वुमेन इन द कंट्री थे उस पे क्या इम्पैक्ट था, तो वो दैट वाज द एलिजिड ऑब्जेक्शनेबल मटेरियल, राइट. Now she was expressing her own view and political thoughts or her philosophy in relation to the constitution of Bangladesh, of which secularism was one of the salient features, right? And of course, the fact that the real situation was deviating from the salient feature incorporated in the constitution. Now, in the third volume of this book, offending passages were written in context of women in her own motherland, right? Now, what was the stand of the Calcutta High Court now? Now, the Calcutta High Court held that the book does not reflect any intention of outraging the religious feelings, to insult religion or religious belief of that class of citizens of India, right? So intention of the author was not deliberate and malicious, क्योंकि deliberate and malicious जो है requirement fulfill होनी जरूरी है. If it is not deliberate and malicious, and for achieving any object of religious hatred, then the offense under 295A is not made out. Now, the order of forfeiture of the book was set aside in this case. In order that a book may fall within 295A of the IPC, it has to be read as a whole and cannot be read in parts. And एक paragraph उठा के उसको अगर वो लग रहा है offensive, तो पूरी की पूरी book जो है वही forfeit नहीं हो सकती. The offending passage cannot be read out of context of the central theme of the book, right? So this was the judgment of Sujata Bhadra versus State of West Bengal, wherein the Calcutta High Court set aside the order of the forfeiture of the book. The next case is of Ramji Lal Modi versus State, which is a 1957 Supreme Court judgment, wherein the Honorable Supreme Court has held that Section 295 is constitutionally valid. इस केस में petitioner was a publisher and printer of a magazine. मैगजीन का नाम क्या था? गौरक्षक. एक मैगजीन थी जिसका की नाम था गौरक्षक, right? In which he published an article, which of course was, found objectionable, which the court held to be objectionable under 295A. कोर्ट ने उस आर्टिकल को ये करार दिया कि ये एक ऑब्जेक्शनेबल आर्टिकल है अंडर 295A, as it violated the freedom of speech and expression guaranteed under Article 19(1)A of the Constitution, which is of course subject to reasonable restrictions. It also violated provisions of Article 25 and 26 of the Constitution of India. Right, so this was a case wherein the court held the matter to be objectionable and 295A was made out in this case. Next is the section of disturbing religious assembly, section 296. Now 296 जो है वो कहता है whoever voluntarily causes disturbance to any assembly lawfully engaged in the performance of religious worship or religious ceremonies shall be punished with imprisonment of either description for a term which may extend to 1 year or with fine or with both. Now the ingredients of this section are that first of all there must be caused a voluntary disturbance. एक voluntary disturbance होनी जरूरी है. So disturbing voluntarily. And किस चीज को disturbance करनी? Disturbance must be caused to an assembly engaged in religious worship. कहाँ जहाँ पे लोग इकट्ठे हुए हैं और वो religious worship कर रहे हैं बेटा, तो वहां पे कोई disturbance voluntarily cause करनी. And the assembly must be lawfully engaged in such worship. That is, it must be doing what it has a right to do. So जो उसकी authority है वो कर रहे हैं और उसको disturb कोई करता है, so that will be a case falling within section 296. इसमें बेटा एक केस था हाई कोर्ट ऑफ इलाहाबाद का, जो कि मोहम्मद जमील खान वर्सेस रामनाथ का केस है. ये इलाहाबाद हाई कोर्ट का केस है बेटा, की जजमेंट है, जहां पे कि इलाहाबाद हाई कोर्ट ने ऑब्जर्व किया दैट एक जो पब्लिक हाईवे जो होता है इज primarily meant for the purpose of traffic movement and is for use of all in a reasonable manner, राइट। तो जो वो तो ट्रैफिक मूवमेंट के लिए है और सबके लिए सबको रीजनेबली उसको यूज करने की राइट है, ठीक है। इट कैनॉट बी क्लेम्ड फॉर वर्शिप एज अ मैटर ऑफ राइट। अगर पब्लिक हाईवे पे कुछ लोग जो हैं इकट्ठे होके हाईवे के ऊपर आप वर्शिप करने लगो और अगर वहां पे आपको कोई डिस्टर्ब करता है तो वो 296 के अंडर नहीं फॉल करेगा, क्योंकि यू डोंट हैव अ राइट टू वर्शिप ऑन द पब्लिक हाईवे, right? This right cannot be claimed. You cannot claim for worship as a matter of right on a public highway. Now, the procession through the public streets, जो कि processions निकलते हैं, must be taken out in such a manner that it does not interfere with the rights of others who are using the road. So ऐसा नहीं होना चाहिए कि जो processions निकलते हैं, तो वो जो assembly होती है, उसको it should not interfere with the use by the others. So anyone trying to disturb that would not fall within the purview of 296. राइट। 297 जो है वो अगेन एक पिक्यूलियर केस के बारे में बात करता है, जहां पे कि इट इज डिक्लेयर्ड एज एन ऑफेंस whenever any person trespasses on burial places, right? So whoever with the intention of wounding the feelings of any person, or of insulting the religion of any person, or with the knowledge that the feelings of any person are likely to be wounded, or that the religion of any person is likely to be insulted thereby, commits any trespass in any place of worship, or on any place of sepulture, or any place set apart for the performance of funeral rites, or as a depository for the remains of the dead, or offers any indignity to any human corpse, or causes disturbance to any person assembled for the performance of funeral ceremonies. Such a person, the punishment prescribed for such a person is a punishment which may extend to 1 year, or with fine, or with both. Now, this is the provision contained in 297. It's a detailed section, but what it talks about is number one, the intention of wounding the feelings of any person or of any religion, right? Or knowledge that the feelings of any person are likely to be wounded, or religion of any person is to be insulted, ठीक है। ये तो हो गया इंटेंशन या नॉलेज की बात। दूसरा है कि क्या एक्ट हो रही है। any trespass in any place of worship, or any place of sepulture, or any place set apart for the performance of funeral rites, or as a depository for remains of the dead, or offers any indignity to any human corpse, or causes disturbance to any persons assembled for the performance of funeral ceremonies, right? So basically, uh, after the death of a person, whatever acts that are done in relation to the same, with respect to the funeral rites, with respect to any place of worship, or any place of sepulture, or performance of funeral rites, right? और any corpse से related, जो कि एक dead body, any human उसके साथ indignity के साथ पेश आना, so that would fall within 297, right? Now, trespass in any place of worship, trespass जो है under this section, what does it imply? It implies not only criminal trespass but also an ordinary act of trespass with the intention specified in section 441, which of course talks about trespass. So trespass का मतलब क्या है यहाँ पे? कोई भी violent या कोई injurious act करना, and committed in a place of worship with such intention or knowledge as is defined in this section, right? So this is another section which deals with offenses relating to religion. Now, when we talk of indignity to a human corpse, हमने अभी बात करी कि this is one of the instances जहाँ पे कि 297 would be made out, जिसमें one of the ingredients of 297 would be fulfilled. So, इसका example हम ले सकते हैं that where a patient dies while he's under operation by a doctor, who after the death removes the liver of the deceased for transplantation to another patient without the knowledge and consent of the deceased wife. उसकी जो heir है, उसकी जो legal heir है, उसकी wife है, उसकी consent के बिना वो remove करता है उसकी liver और दूसरे person की में transplant कर देता है, uh, and the doctor would be liable under this section for offering indignity to a human corpse. So that would fall within the purview of the expression indignity to a human corpse. इसमें एक केस था बशीर उल हक वर्सेस स्टेट ऑफ वेस्ट बंगाल 1953 सुप्रीम कोर्ट. In this case, the mother of the complainant, जो कि जिसका नाम था धर्मेंद्र नाथ, she died and the dead body was taken to the cremation ground by his relatives, right? Now, in the meantime, the accused reported to the police that complainant Dharmender Nath had throttled his mother and she had not died a natural death. Thereafter, the sub-inspector of the police, along with the accused, reached the cremation ground where funeral pyres of the deceased were in flames. The act of accused being malicious and actuated out of old enmity with Dharmendra, he was held guilty of offence under 297 IPC. Now 298, which is the last section, which talks about uttering words, etc., with deliberate intent to hurt the religious feelings of any person. Now, under this section, if any person deliberately wounds the religious feelings of any person by uttering words, yeah, making any gesture in the presence of that person, uh, the such a person shall be punished under 298, right? Now, the purpose of this section is that no person can be justified in wounding with deliberate intention the religious feelings of his neighbors or of others with words, gestures, or any kind of exhibition, right, of any act, right? So basically 298 जो कहता है कि वहां पे deliberate intention of wounding the religious feelings होनी चाहिए. And secondly, requirement is uttering of any word or making of any sound in the hearing of that person or making of any gesture in the sight of that person. Sound, hearing, gesture, sight se related hai, right? Uh, um, any object in the sight of that person. Such a person shall be punished with imprisonment of either description, which may extend to 1 year, or with fine, or with both. Now, in relation to this, there is a case of Shal Bhadra Shah versus State of Gujarat, 1981, Gujarat High Court. Now, since we understand that this section, जो है 298, it refers to oral utterances which are intended to hurt the religious feelings of any person. Therefore, इसकी जो application है in case of written articles which are published cannot be made out. So basically ये uttering of words की बात करता है ना बेटा, gestures करने की बात करता है ना? तो जो written articles की अगर बात करी जाए जो कि published articles होते हैं उनमें 298 की applicability नहीं बनती, right? Therefore जो शैल भद्रा शाह वर्सेस स्टेट ऑफ गुजरात का केस है इसमें editor of a weekly wrote a scandalous and defamatory article under the heading Why Acharya Rajneesh Leaves Pune. अब हम जानते हैं कि ये एक बहुत ही कंट्रोवर्शियल मैटर था जो कि आचार्य रजनीश जिसको कि ओशो के नाम से लोग जानते हैं. तो there was a person who was the editor of a weekly. He wrote a scandalous and defamatory article in his publication under the heading Why Acharya Rajneesh Leaves Pune, and he was prosecuted by the followers of Osho. Now the court dismissed the petition on the ground that 298 deals with oral words, utterances, gestures and not written publications. So basically 298 जो है कोर्ट ने कहा this deals with oral only, not written, right? So for example एक और चीज है sacrificing a cow on Bakrid and carrying to flesh openly within the sight of Hindus and slaughtering in the open despite strong protest by Hindus is a case which would be within the purview of 298 बेटा. ठीक है, बकरीद पे कोई काउ को जो है sacrifice करना, carrying the flesh openly within the sight of the opposite religion which is the Hindus, right, and slaughtering in the open, ये सब जो है despite there were strong protests by the Hindus, these were acts which are found to be within the foul of 298, right? So this was regarding chapter 13 and chapter 15 of the IPC. I hope that this video is beneficial to you and you're able to understand the concepts better through this video. Thank you.